Yep.
Okay, this is Mark Strassman, reporter with Etopia Media News Network. We're about to speak to Randal Picker, who's in Chicago. I'm in Los Angeles. Welcome to Etopia Media News Networks.
Thanks, Mark.
We're going to be talking about technology and the law. Tell us what your background is in both of those and what you do with them now.
Well, I've been teaching in these areas for a while. I teach a course at the university on network industries, which starts with the railroad and the telegraph and ends with the internet, and also teach about copyright law.
Okay, we're going to talk mostly specifically about ClearPlay and the law and technology around it. What's your short take on the legality of what ClearPlay does by creating specialized databases for DVDs and then letting users select their levels of sex, violence, and bad language to create, in essence, their own personalized version of the Hollywood studio production?
Well, you need to understand where ClearPlay and CleanFlix both were at least 2 weeks ago. There's an idea in copyright law which says that only the creator of the work can make other versions of it. And so the natural argument for a copyright lawyer would have been to say that when CleanFlix or where ClearPlay effectively make another version of the movie, of Sex and the City, that they are making a derivative work and that violates a key right held by the copyright owner. The new legislation that was passed 2 weeks ago, the Family Entertainment and Copyright Act of 2005, really creates a special rule seemingly to benefit ClearPlay and anyone else using a sort of a machine-based technology for filtering, and that new law seemingly takes ClearPlay out of this general rule regarding derivative work.
Okay, what does it do to ClearFlix, CleanFlix, and other people who make what seem to be more easily described as derivative works?
Yeah, I think if you look at both the legislation and the statements that were made in Congress at the time it was passed, that this legislation really is directed specifically at a hardware solution of the sort that we see in ClearPlay. CleanFlix, as I gather, their website's not crystal clear on this anymore, actually takes a movie and makes an edit of it, changes that, puts that on a DVD, and then mails the DVD to you. And I don't think this legislation does anything for them.
Okay. What's the status of the lawsuit that was brought by the Directors Guild of America and several of its constituent directors in this area, in light of the passage of the law?
Yeah, again, what's a little surprising about the statements you see on the floor of Congress is that this legislation really is seen as, in many ways, resolving that lawsuit. That lawsuit, at least as I recall, was brought against ClearPlay, and ClearPlay seems to have clear sailing, at least for now.
So the case remains pending, but no one seems to expect it will succeed?
I haven't looked at that in a while, so I want to be careful about saying that. But again, that suit is specifically referenced in the statements made by a number of congressmen, and I think they clearly contemplated that this legislation would resolve it, certainly on a going forward basis. There could be allegations with regard to past damages. Presumably this legislation would not do anything about that, but it seems to create a special exception for, again, these hardware-based filtering devices, and that's what ClearPlay is going forward.
Okay, let's talk about those hardware-based filtering devices. Technically and legally, do you see this as an elegant solution to this problem, the people wanting to have their own versions of major Hollywood productions?
Well, I think it's when you talk about this in class with your students, you always start with the question, well, I am allowed to close my eyes at various points when I watch a movie, right? I don't have to listen to the whole thing. And all ClearPlay is doing, in some senses, is vindicating my instinctive right of being able to watch the parts that I want to watch. And so in what ClearPlay does in a way that CleanFlix doesn't, ClearPlay avoids the copying problem. CleanFlix is clearly making a copy and also making a derivative work. ClearPlay was not making a copy because it works with the DVD that you bring to the machine, so there's no copying involved. You had the derivative works issue, but again, the legislation seems to put that to the side right now.
Okay. What seemed interesting to me about this, and I'd like to get your comment on it as a person in the university, is that the French theory of deconstruction holds that each person creates a work individually for themselves in their interaction with the text. And I'm wondering whether you find this interesting, ironic, or otherwise remarkable that this is a technology for the automation of this kind of deconstructive process.
Yeah, this is sort of like having a digital TV butler for yourself, right?
Right.
You tell the butler, I know this show's going to come on, and it's going to use the following 5 bad words at this point in the show, and I don't want to hear those words, so please help me not do that. So in that sense, it really is about vindicating consumer preferences in a remarkable way.
To use the deconstructionist terminology, it privileges the viewer over the director or the studio.
Well, yes, and that was why the Directors Guild sued originally. They obviously think that there is the vision of the director, and the idea that I can say to Spielberg, well, Steve, yes, I understand you think it's important that I hear the F word in Saving Private Ryan. I've chosen not to do that. There really is a conflict between the Spielberg vision and the consumer vision of that movie.
Is there anything to be said for the argument that if people don't like bad language, sex, or violence, they just shouldn't look at these films at all?
Yes, I mean, this is not a legal question.
Right, I know.
We're clear.
Right, it's more.
But
right.
yeah, I confess. I sometimes when I talk to people about the merits of widescreen movies versus full-screen movies, I ask them, well, who's your favorite pan and scanner? And of course, they don't have an answer to that because the process of taking a normal movie, widescreen movie, and then making it full screen means someone has had to step into the breach, as it were, between you and the director. We have no clue who those people are. There is a lot to be said for saying trust Spielberg, live with Spielberg, and if you don't like Spielberg, go somewhere else.
Do you? Again, this is not strictly a legal question, but how do you see this overall question as an acting out of the culture wars and as an effort by culturally conservative groups or individuals to stick it to Hollywood and just cause them to do more litigation, if nothing else?
Well, I don't know if it's to stick it to Hollywood. I think, over the last decade, those groups would say that they've been marginalized and excluded by mainstream Hollywood. And so they would like to get some of the benefits associated with the work that Hollywood does, the incredible volume of creativity that results there, but not works that are necessarily tailored to their market. Now, there's obviously, I think it's fair to say, more and more of that out there, that works that are really targeted to more conservative viewers. But at the same time, they might like to have your children, for example, excluded from the mainstream culture can be hard. They'd like to participate, but participate on their own terms.
Okay. Is this going to mean, though, that it's a little like homeschooling for moviegoers in a way, that you have more control over what the content is?
Yes, absolutely.
Okay. Why don't we talk a little bit about the issue in general about whether the law is properly keeping up with the advances in technology and what the dynamic there is as you see it as both a technologist and a law professor.
Yeah, well, it's very hard. I mean, because technology moves at a pace that is really quite incredible. The law moves fairly slowly. This, in truth, is an example where, by legal standards, the law has done a pretty good job of keeping up with the technology. But I think we've seen other situations. The emergence of obviously peer-to-peer music, peer-to-peer downloading, where that's taken a long time, and the law is still in the process of getting a handle on that. We are at a 21-year gap between Sony and Grokster, Sony being the key decision in the Supreme Court that is now under review as we've gone from the VCR to peer-to-peer music sharing. To
what extent do you feel that the substantial non-infringing use doctrine of the Betamax case is enough to decide the MGM versus Grokster case?
Well, I mean, there's a question of what the Supreme Court will do versus what I think the law should do.
All right, give us both.
Yeah, as I say, I have an extensive paper on the latter, and so we can talk about that in just a second. I think the Supreme Court, I think it's going to be interesting to see what they do. The Sony case itself was hotly contested, 5-4 decision. The original majority opinion flipped over to becoming a dissenting opinion. Enormous amount of change in the intervening 21 years. So I think it's fair to say that the Supreme Court will, whether it reaches a different result than the substantial non-infringing use test, I don't know, but it's going to have to do a much more serious analysis. It's just a completely different electronic and online world than it was when the court decided Sony in 1984. I think the virtue of the Sony test, certainly the great virtue that the entertainment industry, that the Valley sees, I guess I want to say, is the fact that it's pro-innovation. It creates a innovation safe harbor. You can be sure as a guy sitting in your garage that if you come up with a product that has good uses, you'll be okay because you will have those substantial non-infringing uses. The problem with that test is it doesn't give the designer any reason to take into account possible infringing uses, and obviously some people seemingly have designed products to take full advantage of infringing uses. That's, I think, how you have to see Napster and Grokster, and the real question is whether the court will move from the substantial non-infringing use test to one that focuses, for example, on active inducement to infringe, which is another standard we see in the patent law.
And if that's not there, then the technology will be allowed.
Yeah, again, my paper suggests that we've really reached a different point, that the key distinction between the VCR and peer-to-peer software and TiVo and the iPod is that the latter are all now network products, that those products can evolve in real time and are evolving in real time, that Apple changes the iPod I have in my hands constantly when they update the software, but TiVo does the same thing, and now we've reached a point where we need to update those products with regard to potential copyright infringement.
Okay, now a court ruled last week that the requirement that televisions be equipped with what's called the flag technology was thrown out.
That's correct.
On what grounds did they do that, and why is that important in this discussion?
Sure. The decision last Friday by the District of Columbia Circuit Court of Appeals in the broadcast flag case said that the Federal Communications Commission had exceeded their jurisdiction in implementing the broadcast flag. So it was strictly a question of what the authority was of the FCC in the court's view, and the fact that in mandating that the television equipment recognized this flag, in the court's view, the FCC had overstepped the power that Congress had given to it.
Back up a little. What is the broadcast flag, and how is it intended to work?
Yeah, it's very interesting, and it ties in very neatly to Sony. So in the Sony case, Justice Blackmun, in his dissenting opinion, said, it's possible Sony might be able to someday design a VCR which would recognize a jamming signal so that it wouldn't copy when the owner of the copyright was saying not to record. Well, that's basically what the broadcast flag is, though there is an important difference, and I need to be clear on that because I don't think the most press accounts have been clear.
Make it
so
clear.
So the idea on the broadcast flag is not to control copying of the content, but to control redistribution of the content. So the broadcast flag will be something carried in the broadcast stream.
Is it like a watermark?
Yeah, exactly. And it was contemplated then that the digital devices that receive it would have to respect whatever setting the content owner put on. And so if the content owner said, I don't want my content... Ooh.
It's okay. We had some trouble.
Hang on.
Yeah, okay.
Yeah, you know what that was?
What was that?
Well, sorry.
It's okay. The transmission still seems okay. What happened there?
Okay, yeah, my screensaver kicks in after 15 minutes on a mandatory basis.
Okay, no, we never got a screensaver. You stayed okay here. Oh, it came on me, right? Okay.
Yeah, exactly.
All
so,
right.
So what the broadcast flag says is the idea is that I, as the copyright owner, can control by saying yes or no in this watermark redistribution of my content and the devices.
Right. Meaning the person can, the copyright holder can say you can download it and play it all you want on this machine, or you can give it away and let everybody use it, or nobody can use it after you, or you can let other people use it for a week, or presumably any of those things.
Yeah, and the broadcast flag, I mean, I think the assumption under the broadcast flag had been that most people would, not allow redistribution of their content.
Right, beyond the place where it's recorded originally.
Exactly.
Okay, and this becomes important because TiVo can record mass amounts of all the programming that's on television and make it essentially available on a peer-to-peer network for redistribution.
Yeah, though that's complicated. So there had been proceedings with regard to TiVo where TiVo was implementing a technology that they call TiVo Guard. And TiVo Guard was, the idea there is that you would define a secure viewing group,
right.
And that you would be only able to, as it were, redistribute the content within the confines of this secure viewing group.
And the broadcasters didn't find that good enough.
Well, I mean, the broadcasters weren't happy with that, but at this point they've got much bigger problems because with the broadcast flag itself having been killed off by the D.C. Circuit on Friday, now the copyright holders are probably in the position of going to Congress and saying either implement this directly or give the Federal Communications Commission the authority to do what they did before.
As a political observer, do you think they have the ability to do that?
Well, I think it's going to be a big fight. That's easy to say. That's not a very interesting thing to say.
Right.
And there's a lot going on the DTV front. So you've got a range of issues you're going to have to deal with, not only the broadcast flag, but also the spectrum recapture issues and the timing on that.
Does all this mean that there ought to be a rewrite of the Telecom Act of 1996?
Well, I think that many people think, and I probably think, that the technology has taken off so rapidly since then that we have a law that, while by legal standards is actually a very young law, 10 years is nothing. I teach antitrust. The core statute there was written in 1890. That's the Sherman Act. So 10 years is nothing. At the same time, it seems like a law whose vision has come and gone, and that a rewrite is required.
Could you very briefly summarize what you'd like to see in a new comprehensive telecommunications law?
Yeah, I haven't thought that through, I guess. I mean, I think what has happened here that was unanticipated has been the rapid convergence of what had been separate industries. And so the convergence of what had been, telephone, cable, and to some extent over-the-air broadcast television. The cable guys obviously want to do all of it at this point. They want to do broadband, they want to do cable, they want to do ordinary phone service. The telco guys are chomping at the bit to do that as well. And so that wasn't contemplated. And so now we're at a position where there's clearly more competition than we had, and we might be heading to a point where we could simply let those competitive forces run.
On two sides, both the theoretical and the commercial, I'd like you to address that. Is there, in your mind, a telecommunications equivalent of the unified field theory that Einstein was looking for that would essentially, in a simple way, say these are bits, and here's a way to regulate them that makes sense? And on the other side, from the commercial side, is there an inevitable conflict among the players so that they're never going to be able to agree on anything, let alone some kind of unified field theory of digital telecommunications regulation?
Well, yeah, I mean, I don't know about the unified field theory, but I certainly think it's the case that these players are likely to seek gains through the political process. And so, if you had them step behind sort of the Rawlsian veil of ignorance and say, okay, negotiate rules, not knowing whether to use a cable company or the phone company,
right.
that might work. But they know whether they're the cable company and the phone company. They know exactly how they got to where they are, and they obviously want to take advantage of this process to bolster their position and throw whatever sand they can into the cogs of machinery for their competitors.
But isn't on some level those pipes, whether they're cables, coaxial cables, or fiber optic, or telephone lines, they're all transmission networks, and the difference between a telecommunications service and an information service seems to be the language which is used to debate this, because one can be regulated, one can't. Isn't there enough intellectual firepower in the academic or legal community to say that these are fundamentally the same process and they ought to be treated the same way, and let it go at that?
Yeah, I don't know is the answer. So I don't think they'll let me make the decisions.
Okay, so you're saying then that the ability to muster majorities in legislatures, not to mention persuade judges, is going to be an important factor in the evolution of technology in the next few years.
No question.
Okay, well, you've answered some of mine, and I hope some of our listener viewers, and I want to thank you for taking the time to do this. And I hope I'll have your permission to rebroadcast and redistribute the content we've just produced
sure.
in a way that lets more people see what you had to say.
Thanks, Mark.
Thank you very much.
Good.
Bye.